Your U.S. citizenship is no longer permanent. As of February 2026, the DOJ has officially made denaturalization a top-tier priority. If you lied on your N-400, even by accident, the clock is ticking. Imagine waking up one morning and finding a government notice that says your U.S. citizenship is being challenged. You took the oath, you got the certificate, you built your life here, but now they want it back. Now, before fear takes over, let me be clear about one thing right away. Denaturalization does not happen overnight. The government cannot send you a letter and strip your citizenship. By law, they must file a civil case in federal court. You get to stand in front of a federal judge. You have the full right to defend yourself. But the Trump administration has now made pursuing these cases a top 5 priority. And if there are any unresolved questions in your immigration history, you need to understand exactly where you stand. I'm Alexander Pierce, and on this channel, I give you real immigration facts. Not panic, not politics. Just the truth, so you can protect yourself and your family. Let's get into it. And if you are a naturalized U.S. citizen, or you know someone who is, drop a comment right now and tell me. What is your biggest concern about everything happening in immigration today? I read every single comment. What actually happened? The DOJ Memo. On June 11, 2025, the DOJ Civil Division, under Attorney General Pam Bondi, released an official memo published on justice.gov. Direct link is in the description below. That memo placed denaturalization inside the top 5 civil enforcement priorities for the entire Department of Justice. It states that the DOJ will pursue civil proceedings to revoke citizenship when a person either illegally procured naturalization or procured it through concealment of a material fact or willful misrepresentation. This is not rumor. This is signed government policy with a budget and a directive behind it. USCIS has been instructed to refer between 100 and 200 cases per month to the DOJ for denaturalization review in fiscal year 2026. Reported by NBC News and tracked by multiple immigration law analysts, this machine is already running. A real case, February 20, 2026. Just days ago, USCIS and DOJ jointly filed a civil denaturalization complaint against Philippe Bien-Aime, the former mayor of North Miami. The allegation? Marriage fraud and identity concealment during his naturalization process. This is public record. The USCIS news release is live on uscis.gov right now. Link is in the description. A former elected official, his citizenship now being challenged in federal court, and the administration has made clear this is just the beginning. Who are they actually going after? Let me walk through the priority categories from the DOJ memo. Listen carefully, not to frighten you, but so you know exactly where the government's focus is. National security cases. If the government believes a naturalized citizen poses any national security risk and obtained citizenship through fraud or misrepresentation, they are at the absolute top of the list. Undisclosed felonies. If you committed a felony before or during your green card period and did not disclose it during naturalization, that is now a direct basis for the DOJ to open a case against you. And here is something critical that most videos won't tell you. The government must prove that the misrepresentation was material, meaning they have to show that if the truth had been known at the time, it would have changed the outcome of your original application. Not every mistake or omission automatically leads to denaturalization. The materiality standard is your legal protection, but you need an attorney to help you assess whether your specific situation meets that bar. Financial fraud, loan fraud, Medicaid fraud, Medicare fraud, fraud against private individuals or corporations. If any of that was in your history and was not disclosed, it is on their list. Government corruption. If any irregularity existed in how your immigration benefit was processed, even something you may not have fully understood at the time, it can be used against you. And now, the newest category. As of February 2026, DHS and USCIS are actively reviewing cases where naturalized citizens may have voted before they were legally eligible, meaning before completing naturalization. CNN and the New York Times have both reported on this. The government is treating pre-citizenship voting as potential grounds for denaturalization. If this applies to anyone you know, they need legal counsel immediately. The N400 question that changes everything. There is one question on the N400 naturalization application that I need you to think about very carefully. It reads exactly like this. Have you ever committed, agreed to commit, asked someone else to commit, helped commit, or tried to commit a crime or offense for which you were not arrested? Not arrested, not convicted, just committed. Think about how you answered that. Most people answered no, and many answered honestly. But for some, the truthful answer may have been more complicated. If you answered no, but something in your past technically qualifies, even something minor, even from years ago, and the government finds evidence of it later, that answer becomes the foundation of a misrepresentation claim against you. I want to ask you something right now, and feel free to answer anonymously in the comments. When you filled out your N400, did this question give you pause? Were you unsure what it was really asking? You are not alone. Many people felt confused by this question. Your comment might help someone else watching this realize they need to take a closer look at their own situation. Situations that can create risk. A few more scenarios, quickly, so you have the full picture. A green card obtained through a marriage that was not genuine. If that is now surfacing years later, denaturalization proceedings can be initiated based on the original fraudulent procurement. A green card application where someone listed themselves as single but was actually married at the time. If that is now coming to light, it becomes a material concealment. And the one I see most often, someone was told by a person they trusted that everything was fine. A notario, a family friend, even a less than qualified attorney. If that advice was wrong and the green card was not cleanly obtained, the government can argue you were never lawfully admitted as a permanent resident, which means your naturalization built on top of it was also invalid. And once citizenship is revoked, deportation proceedings can follow. That is a serious outcome, but it is a real one, and it is exactly why acting now matters more than waiting. The truth, and I mean this. Most naturalized U.S. citizens have very little to fear from this policy. If your file is clean, if your green card was obtained properly, if your naturalization application was honest and accurate, if there is nothing concealed in your history, your risk is genuinely low. You are not who this is targeting, but if there is doubt, if there is something you have been uncertain about, if there is a question you answered years ago that you are not fully confident about, the time to address it is right now, not after a notice arrives. Knowledge is protection, and proactive will always beat reactive. What you should do right now. Step 1. Think carefully and honestly about your immigration history. How did you obtain your green card? Were all your applications fully accurate? Is there anything that was not disclosed? Step 2. And this is a high-value action most people don't know about. File a FOIA request today. FOIA stands for Freedom of Information Act. It gives you the legal right to request and see exactly what USCIS currently has in your immigration file before they start reviewing it. You want to know what they know before anything happens. A FOIA request lets you see your own records, your A file, your application history, any notes or flags in your file, so there are no surprises. You can submit a FOIA request directly at foiausa.gov. It costs nothing, and the information you get back could be genuinely important. Save this video right now if you want to come back to that step later. Step 3. If after reviewing your history or your FOIA results there is any uncertainty, consult with a qualified immigration attorney, not to assume the worst, but to get a clear, honest picture of where you actually stand. Step 4. Share this video with your community. Someone in your life may be in a situation right now where this information could help them protect their citizenship. Sharing takes 5 seconds and could make a real difference. Step 5. Subscribe and turn on the bell. Immigration policy under this administration is moving fast. I track every significant development and bring you accurate, factual updates every day. I'm Alexander Pierce. I cover U.S. immigration so you stay informed, stay protected, and make decisions based on facts, not fear. If this video helped you, like it, share it with someone who needs to see it, and drop your questions in the comments below. I will see you in the next one.